accountability and implementation, even as, you know, we express our deepest condolences to the families that have lost their children. Quick recovery to those who are battling injuries in hospitals. But gentlemen, let's move away from matters education and focus on page 5 of the Standard this morning. Night of Intrigues, as you know, this is with regard to the secrets of the night that gave Uhuru his, or Raila rather, his court win. So that story continues on page 5 of the paper. It is said to be a night of intrigues as there was uninvited guests, unwanted calls, and a short-lived tie. So a lot, of course, happened behind the scenes after the hearing finished, and, you know, between then and when the ruling was given by the judges. So let's take a look at this in a bit more detail, considering we have lawyers here in studio. So the court's decision apparently somehow had leaked to boardrooms the night before the decision was read out to the country, and that is also the reason why some lawyers, you know, representing the respondents did not show up in court. But it is said that Justice Maraga initiated a vote of conscience movement among the judges, because initially it is said that it was a 3-3 situation. 3 judges supporting the nullification and 3 judges in favor of upholding the decision of the IEBC. But one of the judges is said to have switched sides as on conscience grounds, rather, to support the invalidation of the election. Dr. Mukwana, what does this say about the judiciary, especially the fact that Chief Justice David Maraga is said to have led this vote of conscience movement?
Okay, thank you, Michelle. Now we can discuss a bit more freely.
It's true.
Now that the decision has been
without the sub judice.
Precisely, without risking being cited for the sub judice.
Which is something that we should actually kill in this country. The sub judice thing doesn't hold water at all.
Yeah, on certain cases.
On all cases. Yeah,
now,
shouldn't.
The night of intrigues. Michelle, I explained last time here that whichever way this decision goes, there'll be unhappiness. And on the night before this judgment being delivered, as your reporters have rightly captured, it was a night of intrigues, many uninvited guests. The truth of the matter is that these judges have families, these judges have associates. They live in our society. Right. You saw the president of the Supreme Court, David Maraga, in church yesterday.
The other day.
So really, there is no total sieve on the flow of information. It is just to what extent of infiltration would it be. But to their credit, they remained quite confidential, at least to the wider public. If the boardrooms knew, we didn't know.
But I understand at 7:46 a.m., the day the verdict was to be read out, there was a tweet by one David D. terming the 4 judges who upheld, or rather nullified the election as the saviors of the country. That was at 7:46 a.m. Judgment was read at about 11:30.
Yes, it is possible, Michelle.
Actually, even the night before, the word was already out that there was going to be a rerun. So as much as there was conscience, and there was also they had sealed themselves from the intrigues from outside, the word was actually out. In fact, even when I was going to the media, I remember I was on one of the media stations that morning, one of the TV stations, and one of the reporters, they actually asked me, are you aware that this is going to happen? In fact, he told me, now I think we're in trouble. I told them I was not aware. Personally, I was not aware, but I realized that the word was already out the previous night, what was actually going to happen. And that is why you see even some of the advocates did not turn up in the morning. But again, look at the issue of consciousness. There are different schools of thoughts or different approaches that we have when we are looking at some of these judgments. Even the judges, the way they think. There's something we call the positivist school of thought. This is where a judge would prescribe to the rule of law and the rule of law only. Then we also have the moralist or the naturalist school of thoughts or approaches in how judgments are made. These are people who will lean more towards what they think is right and wrong. So they will be guided more by other factors like their moral standings, even some of them that they have inherited right from birth and their upbringing, what they think is right and what is wrong. Religious beliefs, you know, they will subscribe more to that. Yet we then have the other school of thought where the positivist one, as I say, where we actually look at the law as it is. And that is what then informs what kind of a decision then the judge will actually reach to. So in this case, the CJ comes as a person who subscribes to the school of thought or the approach of moralist, naturalist, and maybe more of, even more of influence from the religion and his upbringing, so that when he is making a decision, he will at some point want to put aside so much of what are the facts, what is the law, what does it say, and be influenced a little bit more also by what he thinks or what he perceives to be right and wrong.
All right. Dr. Mukwana.
Yeah, my colleague will be right, but for me, so that we do not confuse the public, I think, Michelle, it will help our viewers if we put the decision of the judges in the context of the evidence that was tendered. Because, as we've said here before, the anchor of the petitioner's claim was five-pronged. But without going into those details, the transmission was the main anchor of the petitioners.
Right.
What the defense lawyers did, they spent more time on Form 34A and then skipped the transmission and went to the numbers. So the argument always was that, look, 34A ndio msema kweli. That is true. And so 34A has given us 8.2 million. But NASA was saying, look, ladies and gentlemen, 34A between the polling center and Bomas has been bastardized. It is not the original 34A. So when finally these judges met, and if you had the questioning style of Philomena Mwilu and even Maraga and Smokin Wanjala and Lenaola, the four who supported the invalidation, their question hinged on this 34A. Number one, did it have the security features? You saw that some did not have. Two, did these Form 34Bs have sterilization? Some did not have. Were these forms and votes that finally President Uhuru got, can they be accountable? Where do the five go? You had that question to Counsel Musheru when he said, no, there were six, but where are the five? He was unable to explain. So based on that, there are those judges who stuck to that evidence and the case turned on that. If you listen to the dissenting opinion of Honorable Juang and Honorable Njoki, they did not deny that indeed there were no lapses. In fact, in the dissenting opinion, they said, yes, there were lapses. But those lapses were not adequate to impact hugely on the ultimate result. And that is what had been going. That is the string that had been all through the case. Even the defense, Honorable Muite, Honorable Ngatia, was saying, yes, there are errors. But look, those errors are so small, they could not have impacted to affect the 8.2. So for me, the decision by these judges, the four judges, hinged on the fatality of the transmission. And the goose of those defendants got cooked when the IBC started playing funny with the access to the server.
To the IBC server.
Yes.
So we'll be discussing what next for discredited IBC, but this decision has not been received well by all quarters. Another conversation we'll be having on its own. But Kevin, considering what Dr. Mukwana is saying, transmission was the main anchor of that petition by the opposition. Just yesterday, President Uhuru Kenyatta, speaking at State House, had an interesting question. So they've nullified the presidential election, but these results, the same transmission system also transmitted results for the governor, which, Chief Justice David Baraga sent 47 judges all across the country to witness the swearing in. The same system was used in the transmission of other results, MCA, Member of Parliament. Why is it that we're upholding these elections and nullifying the presidential election?
Michelle, probably before I delve deeper into that, just on the discussion you've been having about uninvited guests and unwanted calls, you know that the history of this country has been, and if you look at the government itself, the three levels of government where we have the executive, the judiciary, and the legislature, Kenya's democratic engagements have been that the three are supposed to work together. But over time, we've seen the judiciary getting much more lived off, and tyranny of numbers in Parliament, both Senate and the National Assembly, clinging very closely with the executive. That is the office of the president and the deputy and all that. And what happened in 2013, in my view, is one of those things that I would say that truly affected the conscience of these judges. And if you listen to those who are privy to the CJ's actions, they'll tell you that he asked them, do we want to be regarded as, the 2013 style? Because really you don't see a scenario where a CJ presides over a presidential petition and then in a few days he resigns so unceremoniously. What does that mean to the judiciary, and especially for a developing democracy like for Kenya? So in my view, I think and I believe that these are uninvited guests, because it was expected that the president would then, or whoever, would make a call to the CJ and tell him, unajua nini, hii kitu mpaka ifanywe hivi. But I think that because we're also talking about independent institutions, and so what is this independence of the institution? In my view, this really presents a very positive progress insofar as our independence of institutions is concerned, and how the decisions are supposed to be taken. And take note that the CJ said, before I read the ruling, I want to say this, that the infidelity of our country lies in three things: its constitution, its people, and the fear of God. I think that those three things really, if Kenyans can be able to embrace those three things, including even the manner in which this decision is being taken, and I think that now that leads me to move on to the next thing. The president's remarks, I think, are quite hurtful. They are unfortunate, and coming from a person who is supposed to be safeguarding the unity, because presidency is really to the level that you can be able to bring all these Kenyans. In any country, people want to believe in peace, love, and harmony, as so says our national anthem. And so if we are going to be looking at how we take this decision, and I remember that the president and his deputy were very at the forefront of telling the opposition, be ready to accept the ruling of the court. Why is it very different right now? In 2013, we saw the same thing happen. Be ready to accept the ruling of the court. And people said, we accept it and we move on. Why are we saying we respect it, but we do not, but we shall revisit? Because then that also invalidates what we're calling independence of institutions. Because what is this thing that we are revisiting? And it is not very fair, because we are now hearing of politicians like Senator Kipchumba Murkomen saying, tutarudi kuangalia hii maneno, and the undertones and even the body language of how all these things are being said, I think are not to the spirit of bringing this country together. And looking at the manner, the environment within which Kenyans operate in, this country is actually split right in the middle. It's a 50-50 scenario. And how the president, in his magnanimity, and I've always said this, that he really needs to be the man who will stand at the top of all these games. He needs to now present himself as a person who will be able to bring Kenya together. And I like his several and